Good evening, everyone. And thank you to Dreamers Together for hosting me. It's such a pleasure to be here. My name is Laura Sepulveda. I'm the managing attorney at Sepulveda Immigration Law. We are located in the Dallas area, but we serve clients throughout the country. I'm here today to talk about T and U visas. I've been in this field for about 13 years, give or take. And these are probably some of my favorite cases to work on. Usually, people have gone through a very traumatic and horrible situations in order to qualify for these benefits. But I see this as an opportunity to take something horrible that happened to them and help them achieve a wonderful and permanent immigration status in this country. So we'll be going through some of the questions that people have. We're also going to be talking about these benefits. If there's any question that you have, since some of these situations are sort of sensitive and very personal, if you happen to not feel comfortable posting a comment in public or sending us our question, you can also reach out to me. My phone number is right there, 469-230-8819, and I'll be happy to answer your questions in a more private setting. Let's talk about T's and U's. So these are amazing benefits. They are designed to help people who are in very, very vulnerable situations. They are for victims of certain crimes and also for victims of severe forms of trafficking, human trafficking. So in order to qualify for a U visa, as some of you may know, the applicant has to be a victim of a qualifying criminal activity in the United States. They also have to show that they have suffered substantial harm as a result of the criminal activity. The harm could be physical or mental. Doesn't need to be physical only. So someone who has been traumatized or is suffering from depression or anxiety or PTSD, that definitely counts for the purposes of showing evidence of substantial harm. The next requirement is that they need to show they have not refused to cooperate with the law enforcement agency that's investigating or prosecuting the crime. These visas were originally created about two decades ago, and basically they're a way to encourage people to report criminal activities, because the government understands that one of the big barriers for individuals to report something that happens to them is the fact that they're afraid because of their immigration status. So these programs were designed to hopefully alleviate a little bit of that and to make sure that people feel a little bit more comfortable and know that they're going to be protected. So as we mentioned, for U visas, the person needs to be a victim of a crime. Sometimes people say, well, I wasn't a victim, but my child was a victim. And that counts. The government understands that the victimization can be complicated. So in addition to considering the direct victim as a victim for purposes of the U visa, they also see the situation of people that are affected indirectly. This happens very often with situations where the victim is a minor. And this is usually because it happens usually with very young children, not always, but many times with very young children. The government understands that a minor or someone of a very young age is not able to cooperate with law enforcement like an adult is. So that's why they consider the cooperation of usually the parents or a guardian in order to evaluate the eligibility for this benefit. So that's how we come up with what's called indirect victims. For purposes of the victimization as well, the age of the minor is frozen at the time of the crime. So the reason why I mentioned this is because sometimes people say, well, I was a victim of a crime when I was a minor, but I'm an adult now. My parents are undocumented. They helped in the investigation, but I'm an adult now, right? I can't do anything. Well, actually, you can. Well, they can. The way that it works is that their indirect victim status is frozen because at the time of the victimization of the direct victim, meaning the child, the person did assist and was the parent of the direct victim. So they can still apply even if the minor is not a minor anymore, which is wonderful. Another way in which we look at victims usually is for bystanders. This is not something that comes up very often, but it happens for certain individuals who are not harmed directly as part of the criminal activity, but they suffer in a severe and unusual way. So, for instance, let's say the example that the government gives all the time is of a woman who happens to be pregnant. She witnesses a horrible crime where someone else is attacked, not herself, but she has a miscarriage as a result of witnessing the activity. That is a bystander. Some of the crimes that are usually covered by the U visa are oftentimes very violent, but that's not always the case. They usually include crimes that are very serious, such as domestic violence, rape, sexual assault, felonious assault, kidnapping, abduction, things like that. But also things that are not per se violent, such as perjury or blackmail, things like that. Now, the government also knows that criminal law is different from state to state. So sometimes certain states don't have, under their laws, a specific crime that's mentioned as part of the U visa requirements. A good example of that is New York. So in New York, under the law, under the law of that state, there's not a crime that constitutes domestic violence. It doesn't exist as a crime in the state of New York. Now, the reason why this happens, it doesn't mean that someone who is a victim of domestic violence cannot get a U visa in the state of New York. The way that the government looks at it in that state is that they look at domestic violence as an umbrella term that covers different kinds of criminal activities. So things like assault, stalking, rape, all of those are crimes in New York. And usually what happens when we have someone who has been the victim of domestic violence is that we apply under one of the other qualifying crimes, such as assault or stalking, or we make the argument, hey, New York doesn't have domestic violence, so they're not going to certify and give me a police report for that criminal activity. But if you look at the elements of the specific crimes, they meet the requirements and the elements of what is usually considered domestic violence for the purposes of the U visa. So that's how we are able to get away with arguing that even though the crime is not a crime that's covered by the U visa statutes, it is a crime that meets the criteria because it is a very similar crime. The elements are basically the same. The government also considers the fact of crimes that are not, sometimes crimes are not completed. It doesn't mean that there's no harm, and it doesn't mean that the person cannot qualify for a U visa. So the government will also consider applicants for this specific benefit if there's an attempt or a conspiracy to commit the crime. So This happens very often, for instance, with cases of assault. Simple assault is not a crime that is covered by the U visa statute. However, felonious assault is. And since we can use the attempt element, many times we're able to successfully argue, hey, yeah, the police report says simple assault. This was not felonious assault, but it was an attempt of felonious assault. And that's how we get around to it, and we're able to help the person. So enough about the specific crimes. As part of the requirement, perhaps the hardest part of any U visa case is getting the Supplement B signed. The Supplement B is a specific form that must absolutely be submitted with any U visa request. It is a form that needs to be signed by the certifying official. The certifying official is someone who works in the law enforcement agency that was investigating or just involved in the legal matter. It can't be from another police department. It can't be an agency. Oh, I know so and so who's a judge. They can sign for me. No, it has to be someone from the agency that was involved with that case specifically. The person who signs a certification basically needs to confirm that the person was a victim. They also need to confirm that the person has been helpful to law enforcement in the investigation of the crime, or they're likely to be helpful. And they also confirm that the crime took place in the United States. This person has to be the head of the agency or someone who is designated by the head of the agency to sign the certification. It could also be a judge, and also some agencies. Usually people don't think of them as being law enforcement agencies, such as like the Department of Labor and Child Protective Services. They also have the authority of signing these certifications. One of the reasons why I absolutely love U visas is because you're able to help not only the principal applicant, but also an entire family many times. For people who are under 21 years of age, when they apply for the U visa, basically the day that they submit their own application, they're able to include their spouse, they're able to include their unmarried children who are minors, of course, their parents, and their siblings who happen to be under 18 years of age. If the person is over 21 years of age, they can include their spouse, and then they can include their children who are under 21 years of age and are not married. So the biggest case that I submitted, I had 9 people, and they all have their work permits now, and I'm so glad, I'm so happy. But it was basically this family. One of the kids had been the crime victim. We applied under the kid with the kid as a principal. We included the parents, and we included all of the siblings. So a total of 9 people. So this is why I love U visas. There are protections for people who age out. So for instance, I applied today as a crime victim, and my child is not married, but is 20 years old. Good. As long as my child is still under 21 years of age when I apply, then they should be fine and they should be covered by the same case. Let's say that child decides to get married. Well, unfortunately, they lose the protection because there is a way to prevent the age out, but there's not a way to prevent someone from, not being able to qualify if they get married. So The waiver that's associated with this. So as some of you guys know, waivers are essentially applications where you ask the government to forgive you because you committed a crime or you violated some sort of law. Usually is for people who came here undocumented, for people who are here, perhaps they're still in the United States after an order of deportation. Many times they have entered multiple times to the United States, all undocumented. At times they may have criminal convictions. So the good news, the wonderful news, is that the government is able to forgive all of that with this waiver that's specific to U and T visas. This is wonderful news because this kind of waiver forgives things like false claim to U.S. citizenship, which, as some of you know, is a big no-no and prevents many people from getting their documents. Another thing that it forgives is for someone who has entered into a marriage for the purposes of committing immigration fraud. That is also a big no-no. Well, guess what? Under this specific waiver, people are able to apply and ask for the waiver to be approved in order for them to get the U visa. The only crimes that are usually not forgiven are very serious things. Not saying that other crimes are not serious, but things like genocide, torture. If you participate in some of those, which is not very likely, but if that's the case, then that could be a problem. Everything else, in theory, you may need to show more or less evidence, but in theory, you should be able to request a waiver and get it approved. So I'm going to stop now. I think people have a couple questions. How long does it take for a U visa to be processed? That's a wonderful question. So right now it takes about 5.5 years from the time that you apply for the U visa until you get the case adjudicated. The problem, yeah, like 5.5 years is not a problem, right? But the problem, in addition to the 5.5 years waiting, is that the government has a very limited number of these visas that they're able to issue every year. So the government can only give 10,000 of these visas each year. This is a big problem, and there is actually a lot of advocacy being done. A lot of organizations are proposing an increase in the limit of the number of visas that can be issued. I believe there's a bill that was submitted to Congress to increase the limit to 30,000, which is wonderful. But as of right now, it is 10,000, and this causes that there's people waiting for these visas for a long time. So yeah, to answer your question, I'm sorry, 5.5 years it takes to process a U visa, but it doesn't mean that you get it after the 5.5 years. It means that the government says you do qualify. We're likely going to put you on a waiting list until we have a visa for you. Once you're placed on the wait list, you can qualify for the work permit while you wait for the U visa. Now, last year, I think it was last year, yeah, the government changed the rules, and they said that right now what they were going to do was to issue what they call bona fide determinations. These are basically, it's an officer who's looking at your application, and they're trying to see if you submitted the minimum that they require to show, hey, I could qualify for this. It is not a pre-approval. It just says this person submitted enough documents. So usually if you submitted your U visa application, the supplement B from law enforcement, your statement, and you have attended your biometrics appointment, and they have been able to run your background check, and everything looks good, then they should issue the bona fide determinations. Those are taking a long time too, but there's a new processing center that's actually being set up as we speak. It's supposed to be fully operational next year. And one of the priorities that the government has said that they're going to pursue is to issue the bona fide determinations. So sorry, that was a long answer. Okay. My husband qualified for a T visa. At his prior job, they haven't paid him for a week, and the owner closed the business. Okay. So we're gonna get to the T visas in a minute. The T visas are basically, it is also a benefit for certain victims, but in this case, it is of human trafficking. Human trafficking could happen in the employment context, like the situation that this person is describing now, but it usually takes more than just not paying. Usually for a T visa, you need to show that the person has used force or coercion or fraud to create a situation where the victim is forced to continue to work. So I'll be happy to talk with this person and see if there's a little bit more that we could grab on to see if there's a possibility for a T visa. But unfortunately, just for not paying an employee and closing the shop, it may not be enough. But again, I'll be happy to talk with you about it. Next question. If a person was a victim of a robbery, can they qualify for a U visa? That's a good question. Short answer is no. Unfortunately, robbery is not one of the qualifying criminal activities for the U visa. The times that I've seen something like this be approved is actually when there's more than the robbery. Usually there is, some sort of threat, use of force, the person is armed, things like that. But just by a robbery, unfortunately, that's not going to fly. And the government has many decisions setting that precedent, saying that robbery is not sufficient. So I'm sorry. Next. Thank you for doing the live today. You're welcome. Can a U visa recipient apply for advanced parole? That's a good question. I get that question all the time. So they could, but there's a problem with that. For people who are, so once a person gets their U visa, they get the visa is good for 4 years. At the end of 3 years of the 4, they can apply for a green card. Congrats, wonderful. Now, one of the requirements for the green card is that the person needs to show, hey, I've been in the United States under this U visa status for at least 3 years. Wonderful, right? The problem with advanced parole is that even if the person is able to qualify and submit the application and get it approved and yada, yada, everything else, when they leave the United States and then they come back, CBP usually tries to process this person as a parolee, not as a U visa grantee. So this person enters under the parole, but they don't issue it only for the 1 day like they do for DACA holders. They just give the parole for the period of time that the person received the parole, and they admit the person under the parole, but not under the U visa status. And that causes a problem because after that person re-enters the United States with the advanced parole, they don't have the presence under U visa status anymore to continue to accumulate that time to reach those 3 years that they need in order to get their green card. So, short answer, can they get advanced parole? Yes. Is it advisable? Perhaps not. The other hiccup with this is that you cannot get a U visa twice in your life for the same crime. So if this person has no other opportunity to get their documents in order, perhaps that's something that they should avoid if possible. So I hope that answers your question. I'm sorry. The next question, someone told me that the U visa is so backlogged now that it may take 10 to 15 years for a U visa to get approved if filed today. Will they give a work permit while waiting? Good question. Yeah. Because of the backlog, which is significant, I think there's like a couple hundred, I think there's like about 300,000 people with pending U visa applications right now. That's a lot, 300,000. So it's going to take a long time. And this is why people are arguing that 10,000 visas a year is just not enough. Anyhow, so the U visa likely is going to take a long time, just because of all the people that are still waiting, and they're basically going to wait for a while. While they wait for the document, they're likely going to get the bona fide determination. The bona fide determination, as I mentioned, is something that started about a year and a half ago. And the government has been going through applications and issuing them. But of course, they have so many people waiting that it's going to take a while to go through all of them. When the person receives their determination of the bona fide, the way that it works is that they get this letter, and then with that, they're able to apply for their work permit. Now, for people, and not all attorneys do this. I always did it for people because I thought, why not? When you submit your applications, you submit the U visa, you submit the waiver, you submit the statements, all of that good stuff. U visas have been backlogged for the longest time. So because we knew that, usually what I would do and many other colleagues would do is that they will submit an application for a work permit based on the expected wait list. So once they approve you, but they say, I can't give you the U visa now because I don't have one, but I'm going to put you on the wait list, they'll send you that letter. Well, guess what? If the government already has that application for the work permit based on the wait list, they can just process that application and save like 3 or 6 months to the client instead of waiting for the notice, sending the application, and getting all sorted out. So, yeah, many people are doing that. Not everyone, not all practitioners were doing it. For people that were doing that, now the government is looking at those same applications that were submitted under the wait list, and they're using them to send a work permit based on the bona fide determination. They're saying, well, it's going to take you too long to get on that wait list, but I find I'm approving the bona fide determination, which gives you the work permit anyhow. Let me use this lovely work permit application that's here in your file, and I'll send you the document. So I hope that's clear. But yeah, it's likely that people, the goal, what the government has said is that they want to issue them, I believe it was like within 3 or 4 months. It's going to take them a while to get there, to be honest. But the idea is that once they receive the application, once they're able to process it and have the bona fide determination, then the person is going to be able to get a work permit. So next question, the waiver you mentioned before for U visa, does it forgive when someone brings someone in the US illegally? Yes, it does. It absolutely does. And I love this. So when people bring, let's say, their cousin to the United States, undocumented, they're crossing the border, they're bringing their little cousin. or they're bringing their children or their spouse. All of that is human smuggling. The government looks at it as human smuggling. They're not paying you for it. You're doing it because you're not going to leave them behind. But the government looks at that as human smuggling. There is a way to forgive that for family unity, but usually it's for very limited circumstances. It's usually for certain individuals who are applying for specific benefits and they're smuggled in their children or their spouse, not their cousin, not anyone else. Now, with this specific waiver for the U visa and the T visa, yes, they do forgive smuggling. Even if your cousin, even if your neighbor, even if other relative, they do forgive it. This is why I love U visas and T visas. Can a permanent bar be waived with a T or U visa? Absolutely. So a permanent bar, as some of you may know, is specific barrier that prevents someone from getting a green card. It's not permanent per se because it does go away, but it goes away after 10 years of the person being abroad. So it's not pretty. The way that it works is that if someone accumulates at least a year of unlawful presence in the United States and departs the country, or if they are removed from the country, even if they didn't reach the year in the United States, they're removed. And then they enter illegally for the second time, or they try to enter illegally for that second time, then they have the permanent bar. The permanent bar says that the person cannot get their green card for 10 years, and those 10 years need to be spent outside of the United States. There's no waiver for this. Usually, for family-based, employment-based, all of the regular, most common types of benefits, there's no waiver. The only exception that's sort of related is for certain backlog cases. So these are situations in which someone has been the victim of domestic abuse at the hands of a green card holder, a U.S. citizen, spouse, parent, or child. We can talk more about that on another day, perhaps. But basically, if someone has a permanent bar and they can connect the abuse to the permanent bar, so the fact that the person was deported or that they left the United States and then they enter undocumented again, if they can connect that to the abuse, you're good. It's not something very easy to do, but it usually works if you're able to show that that the person does qualify for the exception. For purposes of the T and the U visa, yes, absolutely. The permanent bar is forgiven. Absolutely forgiven. Next question. Oh, you guys have a lot of questions. Oh my goodness. Okay, this is fun. Okay. If a child is included in a U visa application, will they age out if they turn 21 before the U visa is approved? No, they will not age out. Yeah. The other thing too that you need to consider is that so I've had situations, for instance, where someone applied for a U visa and they did not include one of their children as part of the application. At times, it was because people will say, "Oh, I don't have the money," and this and that. Well, that's why I don't charge for extra for adding family members, because I hate it. I hate it when people don't have the money and they have this impossible situation where they have to choose which family member they're going to add to the case. So that's why at my firm we don't charge for that. But that's another subject. Sometimes it also happens for people who perhaps they're not in touch with that child. The child is perhaps living in the home country with the other parent. They don't have any contact, or they're not sure if the child is going to want to come into the United States. That's perfectly fine. What matters is that on the day that the principal applicant submitted the application, if they have a child under 21 years of age, that application freezes the age of the child. So that child is always going to be under 21 for our purposes. Now, let's say I didn't include that child because of whatever, I couldn't find the birth certificate. Fine. I'll wait 2 or 3 years. And now the child is over 21. Well, guess what? Because when I applied, that kid was still under 21, their age is still frozen. So it doesn't matter if I added them later on. What matters is that on the day that I apply as a principal, if the kid was under 21, they're always going to be under 21 for these purposes. So wonderful question. Thank you for asking that. Next, so if the U visa has been pending for a year, is it time for them to be receiving a work permit? What do you suggest to do if we haven't received one? Sue the government. I'm not even kidding. So there is this movement, it's somewhat recent, started perhaps about 6 months ago. There's this concept in federal courts where basically you sue the government and you tell them that they're not doing their job and they need to do their job. So you file in federal court and you basically explain this person applied for the U visa next year. They have submitted all of their paperwork. They have gone to their fingerprints. You know, the government is taking an unreasonable amount of time to adjudicate the bona fide determination, which is what allows the person to get the work permit. And they sue them, and many people are being successful in getting their bona fide determinations that way. The main issue that I've encountered, so I don't practice litigation at that level. I only practice immigration law. But one of the issues that I've encountered with people who want to do that type of case is that oftentimes they don't have the money. So it can be quite pricey to do something like this. What I've heard from colleagues is that between $1,500 and $3,000. And not a lot of people have that kind of money laying around. I am very hopeful. The government, as I mentioned, announced that they were going to have that new processing center fully operational at some time next year. They said by the end of the fiscal year, by the end of the fiscal year. They did say that their priorities are going to be processing the bona fide determinations for U visas, which is what we want, processing VAWAs, which is what I mentioned for certain people who have suffered abuse, process the I-61As, the waivers for the provisional waivers for unlawful presence, and processing the other one was the I-730s. So these are petitions for relatives of asylees or refugees. So those are the 4 priorities that center is going to have. And I'm really, really hopeful that as things get moving and they're able to hire all of the officers that they need to hire, and they're able to get the shop up and going and ready, then things are gonna get a lot better. So yeah, so that's my only thing. Either sue the government. That's my suggestion. Sue the government if you have the money. If not, be patient. So next question. Thank you for taking the time to answer our questions. Hope to see more lives. Oh, thank you so much. I appreciate it. Okay, next question. So for T visa, we should probably talk about T visas in a minute. Okay. Next question. Since that U visa recipient has an actual visa granted to them, instead of requesting advance parole, could they just get a U visa foil stamped into their passport, like a U.S. consulate abroad, and present the U visa approval? Yes, this can be done. So technically, it can be done. Practically, it's almost impossible. But so the U visa does not grant multiple entries. When you get the U visa and you're in the United States, that visa is not for multiple entries. When you get it abroad, because you're able to pursue your U visa while being abroad, you just wait for the U visa to be approved. They give you the interview. They give you the interview. You go to the consular post. You get your lovely U visa and your passport, and you come into the United States. And that visa, when it's issued abroad, allows you to come and go. Now, for people who have a visa approved and that has been granted, but they're inside of the United States, yes, they can request a foil stamped into the passport at the U.S. consulate. So the way that this works is that basically you request an interview at the U.S. consulate or the embassy, wherever you have to go in your home country. You request the appointment, and you basically ask them to issue the lovely U visa that's going to be on your passport. And you bring your U visa approval, and they should be able to give you the U visa. The big problem with this is that many people, virtually everyone who has been in the United States and has been waiting for their U visa to be processed, many times, almost everyone has accrued unlawful presence, or sometimes they have other inadmissibility issues, but usually it's unlawful presence. So as you guys know, when someone enters the United States undocumented, they start to accumulate unlawful presence. When someone enters the United States with a visa, let's say the visa is for 6 months, the first day after the 6 months are over, they're going to start accumulating unlawful presence. When they depart the United States for any reason, if it's not with advance parole, then that triggers the unlawful presence bar. So if I accrued, let's say, 5 years of unlawful presence, and now I receive my U visa, yay, wonderful. But then I want to do this. I want to go to my consulate back home, to the U.S. consulate back home, and get the U visa so that I can come back here. That's great. The problem is that I need to align everything perfectly. I need to get the appointment with the consulate. I need to apply for a waiver for the unlawful presence that's going to be triggered the second I leave the United States. And I cannot do this waiver beforehand, by the way. It doesn't work like the 601A. So I need to do all of that and get everything set and processed, and the waiver adjudicated, approved, done. And I need to go get my visa and come back in less than 90 days, which is not really possible. I've seen it happening, but it takes a lot of work and people really risk it. So unless it is absolutely necessary, I don't think it's a good idea. If you are in the United States for more than 90 days while you have the U visa status, then you're not going to be able to get your green card through the U visa. And that's why we don't recommend people doing that. So yeah, I wish things were quicker, but unfortunately, it's going to be very difficult. So is it too late? Next question. So is it too late to add my parents in my U visa application? I applied 3 or 4 years ago. It's definitely not too late. So if you were under 21 at the time of, if you were a minor at the time of victimization, you can include them. That's fine. If you're under 21 at the time that you applied, you can include them as derivatives. That's fine. So it is definitely an option. Next question. My parents submitted their U visa in late 2022. When should they expect to hear about their work permit? I don't know. So as I mentioned, I think that things are going to start moving quickly when the new center starts running and things get into a routine, but it's likely that it's going to be a couple of years. I had a call the other day with an old client. I submitted her U visa, I think in 2018, like November, and she got the work permit last year. So it could be a couple of years, unfortunately. Yes, mandamus. Yeah, mandamus action. That's the one action that I was discussing. Someone posted that comment. Mandamus. Yes, it is the federal action where you sue the government. You tell them, hey, do your job. Next question. For the child under 21 that the age freezes, does it still count that the U visa was years ago? Yeah, doesn't matter. If the person has a U visa, has a U visa pending or approved, they should be able to include the child. My only thing is that there is a separate process for that where you're allowed to include certain relatives at the time that you are applying for your green card. So the way that this works usually is that, we don't see a lot of these, but it is an option for certain people, especially for people who are, they have a new spouse, which oftentimes happens. So let's say someone was single when they applied for the U visa, they get the U visa, lovely. Now they are about to file for the green card and they just got married. Congrats. Their spouse is undocumented. Well, the U visa is approved, has been approved. This person is not applying for a green card. Really? You're going to make them wait? No. What you do is that you can submit a different application. Is dependent. It's not like a derivative. It works a little bit differently, but it's basically a petition for a relative of a U visa principal, where that relative has never had U visa status. The way that it works is that you can submit the application at the same time that you apply for the person's green card, or you can submit at a later date, and that person is also going to be able to get their status under the U visa law, which is wonderful. So it's a little bit complicated, but there's definitely options. Next question: if someone wants to add their spouse to their U visa application, can they do that even if they're on deferred action? Yes, you can do that. Will the wait time be the same? Yes, it will be the same. It's not going to take longer if you're your spouse. Or will the spouse get the same deferred action status as soon as they file their application? Well, in theory, yes. In practice, it's going to take a while for the government to issue that deferred action determination. But usually, once a person is a derivative, one option that you could pursue is write a letter to the processing center and just tell them, hey, I included my spouse. This is the evidence saying that my spouse is included. I have deferred action. Please extend the deferred action determination to my derivative spouse. So that's an option. So great questions. Let's talk about T visas. I hope that people are not too bored about U visas, but I really wanted to touch base about T visas because I feel like it's a very, very underutilized benefit that helps a lot of people if they're able to pursue it. So T visas are for people who have been victims of severe forms of trafficking. So these are things that are not only the usual concept that we have of human trafficking. I feel like usually when I talk to people about human trafficking, they think, oh, but no one brought me to the United States against my will. Well, yeah, that is human trafficking if they bring you to the United States against your will, but also it can happen in other situations. Actually, most of the human trafficking situations happen after the person enters the country. not while they're entering the country. Usually, the way that we have to think about these things is to examine three important things: the process by which the person enters into the human trafficking situation. So it has to be through the recruiting, transportation, or harboring someone. You have to be engaged in that process as a trafficker. Um, the means the trafficker needs to be using force or fraud or coercion. So it could be physical force, it could be threats, it could be anything, but basically something that puts the victim in a situation where they're afraid to say no. They're fearful that something will happen, or they feel that they don't have another option. They can't leave that situation. And the third thing that we have to evaluate is the goal or the end of this scheme. So all of this needs to be for the purpose of um, having the victim participate in sex trade, um, prostitution, forced prostitution, or involuntary servitude, or some sort of like forced labor or debt bondage. These are situations that are very delicate, but it happens actually very often. So, for instance, someone who, okay, let's say I get a coyote to bring me into the United States, and I come to the United States, and we get to one of those safe houses. For those who are not familiar with this concept, usually smugglers will have safe houses throughout the journey where they keep the people, and then they transport them to another place, and then they keep going. Now, the problem with this is that sometimes they take advantage of some of these individuals. For instance, they'll ask for more money. They'll say, "Oh, I know you paid me this much, but you need to pay me this much, otherwise I'm not gonna let you go." Or you have to do this, otherwise I'm not gonna let you go. So it has happened at times where individuals are being forced to engage in commercial acts in exchange of their freedom, essentially, or they're forced to work at a safe house. They're forced to clean up, or they're forced to maybe keep an eye on the other people who are around. They're forced into that situation. They are not free to leave. And that forced labor is what allows a person to qualify for the T visa, as well as, of course, being able to show that they have not refused to comply with any reasonable requests for cooperation from law enforcement. So, as we talked, the U visas and the T visas are tools that were created to encourage people who were victims to assist law enforcement. Good. With a U visa, the certification from law enforcement is absolutely necessary. That certification is the document that the law enforcement agency gives you that allows you to apply for the U visa. With a T visa, yeah, you could get the certification, but it's not absolutely necessary. The T visa is more flexible in that way. And usually, as long as you're able to show that you, as the victim, you try to bring attention to this issue. You try to report the criminal activity of the human trafficking to law enforcement. It should be fine. You don't need an investigation. You don't need an arrest. You don't need anything. All you need to show is, hey, dear police department or Department of Labor, whoever, this is what happened to me. I'm willing to tell you everything. I'm willing to testify. I'm willing to help out if you want to open up an investigation. If they decide not to do it for whatever reason, that's not your fault, and you can still pursue the T visa. So it happens actually very often were in situations of labor trafficking. Usually these cases are handled by the Department of Labor, and the Department of Labor, as many federal agencies, are not, staffed with enough people, and they have limited resources. So of course, if I come in with a big human trafficking case with like 1,000 people that were affected, I'm probably gonna go after that and not go for the one person if they don't have the resources to investigate the activity. Doesn't always happen, but again, it is something to keep in mind. Usually these situations happen a lot in agricultural work, for people that are brought here to do specific work in fields and farms and all of that. Restaurants, it happens very often with domestic workers, and also a lot in factories. But it could happen anywhere. Those are just some of the places where we see them the most, as well, of course, as situations where there's prostitution involved. So the T visa, something I like to mention too. You're also able to bring in into the case your relatives, but sometimes not only your children and your spouse and your siblings. So there are two ways in which you can add other people to your T visa case. One way is based on the relationship with that person. So similar to the U visa, if you're under 21 when you apply, you can include your spouse, your children who are not married and they're under 21, your parents, and your siblings under 18 years of age, just like the U visa. If you're over 21, you can bring your spouse into the case and your unmarried children under 21, just like the U visa. But with the T visa, there's another category that is not based only on the relationship. The government says that if there is a danger of retaliation because the human trafficking victim came forward and testified and contacted law enforcement, and the trafficker could take a retaliatory action against them or the relatives who happen to be abroad, you can bring in some other people. Usually this helps. I think it covers parents, unmarried siblings under 18 years of age, but also the children of derivatives. This is wonderful because not only, let's say I'm a T visa applicant, I include my child who was under 21 and unmarried. Wonderful. The T visa took a while. Now the person is, my child is going to come to the United States. Wonderful. But guess what? Now my child has a child of her own. Congrats, I'm a grandmother. So this specific section of the law allows me to bring my grandchild as a derivative as well, if I'm able to show that the human trafficker could take a retaliatory action against my family member because I came forward and I went to law enforcement. So yeah, I hope that was clear. There are, of course, child protections. There is the waiver that's basically the same. It's very flexible. And the good thing about the T visas, one of the many good things about the T visa, is that even though the government can only issue 5,000 visas per year, so less, half of what the limit is for the U visas, the limit has never been reached. There's not enough applicants. They never reach 5,000 per year. So there's always T visas that are available. And that means that the processing time is about a year and a half, which is wonderful. So let's answer some questions. I think someone had a question earlier about T visa. So for T visa, if the employer threatened to call ICE on the employee if they don't accept withheld wages, will that be enough? It could be enough. You have the threat, so you have the use of force. You have the scheme to have this person continue to be employed there, despite the fact that they're not being paid. Now, my question is if they transported the person, if they harbored them, if they recruited them under fraud or maybe force. I think it would be worth having perhaps a conversation with that person, or if this is someone that you're trying to help, feel free to reach out and we can talk about it. But yeah, it sounds promising. I just, as a side note, I have a case. I have some visa cases right now, but there's this case, just as an example. This person came here under a visa to work in a farm, at a farm. They were recruited in the home country in Mexico. They helped them with the process. They brought them to the United States with that specific visa to work at the farm. When they got to the farm, not only he was working and he was not getting paid what he was supposed to be getting paid, they also threatened him with a weapon. And some other things happened as well that were not pleasant. So we're able to show not only that that person was a victim of fraud, so that's your fraud, coercion, or force requirement. They were recruited and transported and harbored, and all of this was for the purpose of the labor situation, of taking care of taking advantage of the labor of this person. So again, I would love to talk more about it with you if this is your question. So let's see if I can catch up to the. Oh my God, so many questions. Okay. Okay. I applied for. I applied for a U, but okay, I think this is a typo. Okay, I applied for a U visa, I'm assuming, but also advanced parole. If I leave with advanced parole, will affect my U visa. Usually, no, if your advanced parole is based on something else. So for instance, if you have your DACA and you're applying for your advanced parole based on the DACA, that should not affect you. While your U visa is still pending and you don't have the status yet, you can, as long as you have the parole and it's valid and you're coming and going within the time frame, that's okay. Just be mindful that things may get a little bit more complicated after your visa is granted. Do virtual kidnapping counts as T visa? I don't know. This perhaps is a very ignorant comment. I don't know what virtual kidnapping is, but kidnapping could be involved in many T visa situations. The kidnapping was in Mexico. Okay, the kidnapping was in Mexico. Mom is undocumented, and sister is citizen. There was an FBI case opened. Call me. It could be something. I would really like to talk more about it with you. So this person, they had there was a kidnapping activity in Mexico. The mom is undocumented and the sister is a citizen. It could be. The thing is that for something like this, for the T visa, the person needs to be in the United States on account of the trafficking. So I really would like to know what happened. If the person was kidnapped from Mexico, maybe brought here, and that's why the FBI was involved. Or if this is not a potential T visa, because the person is not in the United States on account of the trafficking, if there is a way that we could do maybe a U visa, because kidnapping is one of the qualifying crimes. Can you apply for a U visa after 20 years of having been the victim of a crime? Yes, absolutely. So the government says that there's no time limit for the U visa or the T visa to apply. Now, the longer you wait, the harder it gets. Sometimes people just don't know that they could have pursued this benefit, and that's fine. The immigration laws are not going to penalize you for not applying right away, right after the crime took place. However, for purposes of the U visa, where the law enforcement agency is absolutely necessary, that's where things could get a bit tricky. So the law enforcement agency that was that was involved in the investigation or the prosecution of the case, they don't have the obligation to sign the U visa certification. If they say, I'm not going to sign, I don't like you, guess what? There's nothing that you can do. There is a couple states throughout the country that have passed state laws that dictate that the agencies under their state law, like their state agencies and local agencies, have to consider the U visa certifications, the requests, and process them. It doesn't mean that they have to approve them. It doesn't mean they have to process them. So for instance, I think Colorado passed a law fairly recently that talks about that. And I think it gives like 90 days or something to process a U visa request. I know New Jersey passed a law probably in like 2018, 2019, where they said that law enforcement agencies in the state needed to create a protocol for people to request U visa certifications and for those requests to be processed. Again, depends from place to place. Unfortunately, that's not the case for many other states. Many other states, they, for lack of a better term, they don't care. So they're not going to push their law enforcement agencies to process U visa certifications. It is very much unfair. I know, but yeah, you could have basically the same crime, if not worse, in one place. And if that law enforcement agency, if that police department, if that prosecutor's office is not willing to sign the certification, you're not going to be able to apply for the U visa. Where if the crime happened in another place that does have a immigrant-friendly policy, where they are going to take the extra step of like trying to help this crime victim, then you should be able to get a certification and pursue the case. So again, it's very much unfair. So to answer the question, yeah, there's no time limit. I had a case that I think it was 1996. The crime was in 1996, and the certification was issued, but it is more difficult. So yeah, and I think those are all my questions. Yeah, so this has been lovely. Thank you everyone for being here. I really appreciate it, and I think we covered a lot of ground today. I look forward to any questions that anyone else may have. Again, my phone number is right there. If you want to call me or send me a text, send me a WhatsApp. I'll be happy to talk with you. We handle a lot of these cases. We really care about these cases and about making sure that people have access to the right information. And this is why I'm so happy and so thankful that Dreamers Together was willing to have this live with me. And yeah, that's about it. Thank you, everyone. Have a lovely evening.